Now to an earlier story, and a Facebook post will cost a man some 5 million shillings in damages. This follows a ruling by Justice Mbogoli Msaga that one Peter Kisa's post on a social media platform was libelous to Teso North Member of Parliament Arthur Papa Odera. And we want to have that conversation just to understand more on what exactly this is, and I'll quickly hand you over to Willis Raburu and Mutegi Njau as they seek to get more information from a defamation lawyer. Willis?
All right, thank you very much, Hugo. Of course, that case, like we were talking in the morning, somebody's 5 million shillings, which that's one way to look at it because of the case that definitely sets precedence. And to paint the picture for us, you have our lawyer Ndegwa Njiru, who is joining us, and of course Mutegi Njau as well, to just put these matters in perspective. And I'll give Mutegi the first go because he's been itching since morning to talk about this. So Mutegi.
This is a new phenomenon of libel.
Yes.
Because traditionally we know libel is what's published.
Yes.
And the publishing used to be either in radio, TV.
Yes.
Social media was not there. This is a new phenomenon. What does it end?
You know, as technology grows and as man grows, there is a definition that we say that the law develops with or grows with the growth of the society. So it comes at a particular time when the law has to address some new phenomena that were not previously there during the definitions of all these issues of libel. And the question of libel, the only thing that needs to be done for it to be cited for libel is publication.
Yes.
If it is published, whether in the social media, whether in the newspaper, or even through a letter, then somebody can be cited for libel. Probably the question then is, to what extent then can one enjoy the right and the freedom of self-expression vis-a-vis the question of defamation, libel in the social media, Mr. Mutegi?
What do you mean freedom of expression?
Does it
your freedom of movement ends when you get to me.
Yes.
Isn't it?
Yeah.
So what freedom of expression is?
You know, the new constitution is one that has brought all these dispensations. Previously, we never used to speak about the right to self-expression, despite the fact that it was there. Probably having its history in 1948 during the enactment of the Universal Declaration of Human Rights. All these rights were enclosed or appreciated by that document, but most of the nations never appreciated them by codifying them into their particular laws, into the particular municipal or domestic laws. So the new constitution appreciated the whole concept of freedom of expression. And when it appreciated that, it then means it also gave some limitation that you cannot have the right of self-expression unlimited, because that would bring a bit of anarchy. And that is why, if you look then at the law of tort, the law of tort is issues of the civil wrongs. And also you also look at the penal code. It has appreciated that you cannot have the right to express yourself indefinitely. It has to have a limitation insofar as that your right to express yourself does not infringe your neighbor's right. And that is what the court was facing.
As I said, your freedom of movement.
Yes.
And association.
Yes.
And when you step on my toes.
Yes.
But what about what does it mean then? Because like we were discussing in the morning, what then is the limit? Because if I go on social media today, for example, and say Mr. Ndegwa is a bad man, and I cite my reasons why I think you're a bad man, then will you go and say, because I am a lawyer and I'm practicing, this is now harming my reputation, etc.?
You know, in the law of defamation, and this is not the first time that we have this law of defamation. It has been there since Kenya was, because we borrowed these principles from the common law. It has been there. It's only that now it has come up into sparks during this particular time when you want to limit your neighbor from speaking things about you. Insofar as you say that Mr. Ndegwa is a bad person, and I am able to justify that, then you cannot cite me or cannot cite you for libel. But in the event where you're not able to justify your statement, say like the case that was in court, which said that a particular MP has embezzled, I don't want to mention names because I don't want to be cited, has embezzled public funds. As long as that allegation can be subjected to a test and it pass that particular test of truth, then you cannot cite someone for libel. And I am saying that this whole aspect of defamation, libel and slander needs to be exercised with a lot of care, such that it doesn't become a barrier or a clog towards exercising and enjoying the right of self-expression. Because if it is going to be exercised in a judicious way, in the way it was exercised by the court, it then means that nobody will be in a capacity to expose the wrongs and the vices in the society regarding our leaders. Remember the new constitution under Article 10. It has provided for the principles and the national values. And one of the national value is the value of accountability and transparency and public participation. And the question then is, can there be accountability, can there be transparency, can there be public participation without exposure?
Well, but you have said it very rightly, that exposure will not, first of all, it must not be malicious.
Yes.
That exposure must be true.
Yes.
Factual, must be accurate.
It must not be intended to slight.
Yeah, exactly.
Yes.
This gentleman who wrote that Facebook post.
Yes, yes.
He wrote that the certain member of parliament stole or embezzled or whatever. The writer did not go to defend himself.
Yes.
He did not recant, he did not remove.
Yes, he did not even apologize.
He didn't apologize.
Yes.
Because one of the things that can help you if you defend somebody, if you say, I'm sorry, I made a mistake. I didn't mean you.
Yes.
I did not mean you, I meant so and so.
Correct.
Then there is mitigating factors.
You have mitigated.
But this man is what we call impunity.
Yes.
He said somebody has made a mistake.
He is impunious.
Yes.
Yes.
He did not go to court to say, I'm sure this happened.
Yes.
I have this evidence in bulk.
Yes.
This CDF money which he got, he was supposed to build a dispensary at point number 1.
Yes.
He did not build a dispensary.
Yes.
Instead, this money was banked, or he gave it to his brother, or whatever. Give evidence that the money was abused or misused.
Yes.
He didn't.
Yes.
So that's the problem.
Yes.
But I think the lesson to learn here is this. Because people who are in Facebook have seen a lot of abuse in Facebook.
Yes, they actually
people abusing others in Facebook. You find an argument started, somebody says whatever they want to say. The comments which are written there. You find somebody has commented there, the other abuses them, say, you Jaluo.
Yes.
You know, you are saying that just because you are Kikuyu.
Yes, in a very slanderous way.
In a very slanderous manner.
Yes.
There's a big lesson to me.
Yes.
Your fear is that people are going to be curtailed limitation of...
My fear is that, again, if you look at Article 10, another principle is the principle of democracy.
Yeah.
And I and you, we all appreciate that we have our own ways in which democracy is defined, and especially when we are now going to the electoral process. One of the way that Kenya's democracy is defined is actually through the principles of defiance and the principles of the principles of agitation.
Yeah.
Like we saw in Parliament the other day during the whistleblowing. Yes. That was agitation, and this agitation has a history in Kenya all the way back from 1990 when we are trying to change Section 2A of the old Constitution.
Not even 1990, even before. Even Ariduku in 1922.
Probably even before I was born.
Well, exactly.
So the question is,
even during colonial times there was agitation. So even Kenya Kenyatta was agitated.
Absolutely. So the question is, I must not only agitate in a manner that appeases or in a manner that impresses my friends. I might agitate in a manner that pisses you off. When I agitate in a manner that pisses you off, are you going to cite Justice Bogoli's decision?
No.
So does that open a gate like...
No.
Because like Mutegi says, Facebook is going to be all this. I can go and say Mutegi used this.
If you agitate,
yes,
or you say somebody has done whatever they have done,
yes,
is that matter of public interest?
Yeah, again,
the question of public interest is very crucial.
And that's why I talked about public participation.
Well, the public participation.
Yes.
If you say that me as a private person,
yes, in
my own private capacity,
yes,
just because me and you are fighting for a woman,
yes,
you go and do whatever you want to say, bad things about me.
Yes.
And it's personal between me and you, and you put it in the public.
Yes.
And that's not democracy.
So will it be cited? Can somebody go and say based on this?
I am seeing a possibility where people are going to start taking advantage of Justice Bogoli's decision to silence me if I am not really impressed by what you are saying, and more so in the political competition. Mr. Mutegi.
No, I disagree with you, because
yes,
Justice Bogoli issue and why you wanted the money,
yes,
is that person who made the claims never want to prove.
That's a mistake that he did.
You see, if I am a politician or leader in wherever,
yes,
I'm a public person
yes,
now. If you find me in a bar drinking and fighting,
yes,
or you find me in some brothel somewhere,
yes,
and you can prove that I was that brothel,
yes,
and I claim to be a Christian,
you cannot cite me for libel.
You can't. It's true. You have evidence.
It will be difficult to.
But if you say Mutegi Jau is a person from Citizen TV,
yes,
that he was found drunk,
yes,
that he was seen in some Koinange street,
yes, and
I was not there.
But then what you said about
it must be true.
Yes,
it must be factual.
Yes, but
you can be able to sustain it.
What if, like Mutegi was saying, after, let's say, this particular gentleman using this case, what if he had apologized?
If he had apologized,
then the money would be less.
He would have mitigated.
But they would still be...
Yes, because an apology, and why many people do not want to do apologies when actually they've been called upon and they've been cited for defamation, is it's actually an admission
of guilt.
So you've admitted liability, that yes, I've defamed Mr. Mutegi. So the only question that the court will be left with is to quantify quantum. That's why he could not even apologize an admission. But in his defense, because even the charges or claims for libel or defamation, they have defenses. One of the defense he could have brought is justification. That's what Mutegi is saying. He made a mistake. He never brought that particular evidence to say yes.
Justification.
He never applied this money in the manner in which it was intended.
Justification means you can justify what you are saying.
Correct. So that's what
this man misused CDF money.
Yes.
He was supposed to do a certain project.
Yes.
He didn't do it.
Yes.
But there's something else that we must also look at when the court is giving this, is awarding these damages. You realize the court awarded general damages and exemplary damages. Exemplary general damages is like the ones that Mutegi is saying. My reputation has been injured in the eyes of the reasonable man. They have started looking me with a lot of dislike, hatred, and contempt, and as such, I am no longer able to hold out myself in the manner which I always used to. So you awarded general damages, but again, the court also went further to award exemplary damages. Exemplary damages are in the nature of punitive measure, which are to stop, and which are actually intended to deter. So I'm not just deterring that particular person who has libeled me. I'm also deterring Mr. Mutegi. That's why I'm saying this decision will actually act even indirectly to bar people from speaking despite the fact that they know the truth. So our obligation.
So if you are judge, what would you have done?
I would not have done anything different as long as a defense has not been brought. I would still have done it.
The same thing.
But now we don't have to stop there. We have to expound and probably use these platforms to educate the people.
Exactly.
That for you to be cited for defamation, you must have done A, B, C, D. You must not have done A, B, C, D.
For you to be cited, let's just do what. For you to be cited for defamation, what? For you to be taken to court.
Yes. One.
What are the?
You must have. Remember, it's not everybody who is capable of being defamed. For instance, for you to be defamed, you must be having a reputation in the society. I mean, and this I say with a lot of humility, probably my mother in the village is not capable of being defamed, because the many people who knows are only in that particular village, and probably myself, and now Mutegi Jau knows that he's there because I've mentioned her. So she can never be defamed. But you can, Mutegi can be defamed, you can be defamed, and any other person who has a reputation in the society is capable of being defamed.
So for instance, this MP, the judge said, among the electors, the people who elected him, now that he is supposed to have, he probably may not win an election because of that. Because he is supposed, it is alleged, which is untruthfully, it hasn't been proved that he misused CDF money.
Correct.
So his reputation among the voters is completely damaged.
It's completely damaged. So that has actually cost him it might cost him his seat. So having defined the person who is capable of being defamed, then the statement being made either in writing or by words must be able to make a reasonable man, like Mutegi is saying, the villagers who elected this member of parliament, to look at him with a lot of dislike. I dislike you because you have misused my CDF funds. I hold you with a lot of contempt because you have misused my CDF funds. I look at you with a lot of dislike. So if those ingredients and those tests do pass, then that particular person has been defamed, and then he can raise a claim for either libel or slander. Slander is the one that is now being spoken and not being written. And of recently I've seen so many cases being taken to court about defamation. I think there is one between Martha Karua and Honorable Kuria. There are other several of them. Yes. So there is even one between Honorable Chris Murungaru and the former PS John Githongo. So the question is, and we must be very careful in the way we implement or apply this ruling, is that it must not act, or it must not be used to act as deterrence to bar people from speaking even when there is truth in it. Yes.
But the point of the matter is that whoever is blogging or whoever is posting on Facebook or social media,
yes,
they must be able to prove what they are saying.
Yes.
You cannot just say so and so and so because it's social media, and you think you are not. You think you are only posting by yourself.
You are limited.
You see, in newspapers and radios, there are editors.
Yes.
Who look at what you have written.
Correct.
When you're on TV here, your bosses they check you.
Yes.
So that if somebody calls from outside that says Mheshimiwa so and so stole somebody's wife.
Yes.
When you're in the studio, tell that man, no, we cannot entertain that. That's information. So you disclaim.
And you know, Mr. Musa,
so you disclaim. But in social media, it is only you
and your phone.
And your phone.
Yes. Or your computer.
And your computer.
And that's what we are saying.
Very dangerous.
And that's what we are saying. Now that the law of defamation, which preceded the issues of the social media, then Parliament might probably have to sit down and legislate on how to use the social media. Remember, the social media has come and found the law of defamation in existence, but it is now acting in utopia.
Yeah, because when defamation was being, our libel laws were being written, there was no social media.
There was no social media.
Most of the cases go with the improper use of a telecommunication device,
which themselves are a bit embarrassing in nature. Because at the end of the day, even if you cite me for criminal defamation or utilization of bad utilization of this social gadget, the question is, the person that I have attacked in my social media, where does his claim lie? And in the event where there is a defense because of lack of regularization in the social media, how will the defendant be able to defend himself? Because there is a serious lacuna in, or serious shortage or lack of a particular legislation to regulate the social media. Remember, we have seen there's a certain blogger who is always in court because of the social media, because he does not know where his right begins and where it ends. Yes. So there is need of urgency to relook into how the social media can be legislated. Yes, because if it is acting in Kenya, it must be regulated. Yes.
Right. But I think the most important thing for the public to know is this: that whatever you say,
you are at your own.
Media, you are at your own.
Yes.
And once it goes there in the world.
Yes.
What I don't know is about the time limitation.
Yes.
Because like that, when you are Facebook, for how long is it there?
Oh, the law.
Because when you're on TV or on radio.
Yes.
TV and radio, unless it's recorded, it ends there after that.
Yes.
But in a newspaper can stay for.
Correct.
Yes.
Correct.
And information laws in this country last 1 year.
Yes.
If you don't sue by 1 year,
it elapses.
It elapses. But in social media, which is very temporary.
Yes.
Should it also last 1 year? If somebody blogs now
and pulls it down,
it is 3 weeks, it's not there.
Yes.
Because Facebook is not there 3 weeks.
No, but you can go back to posts. So maybe blogging, if you pull it down, perhaps.
Yes.
Because for Facebook, you can go back to even 2011.
So that is what we are saying, that we need urgency to regulate this. Remember,
what is time limitation for bloggers, and
we leave it to speculation and to the wisdom of the judges the moment the matter is presented before him. I remember there's a time there was these issues of the deadbeat.
Right. Yes.
And so many people were cited and mentioned in the deadbeat. We are the ones who went to court and got an injunction of the deadbeat to stop publicizing, because people never knew where to go. People never knew what to do. People never knew what right has been infringed. So we must implore upon Parliament to relook into this matter. It's a fresh issue, and I believe it's not a challenge limited to Kenya. It's a global challenge, so that we can be able to get a way of trying to codify the whole aspect of the social media, because again, it cannot be left unregulated. Especially when I and Mr. Mutegi have agreed that Kenyan's politics is defined by agitation.
Right.
Yes.
Right. All right. Of course, it's a topic that we can continue discussing, but definitely, like Mutegi said, be careful when you're out there on social media, and definitely a case that sets a little bit of a precedence, and it will be interesting to see what will happen after this. I can see a lot of comments on social media.
I'm sure there will be a lot of suits following this.
Yes,
because the money is attractive.
Yes, it's very
like 5 million, 1.3.
There will be a lot of
very attractive.
Many lawyers.
Yes,
we'll
now waiting.
We'll be looking at what is called
I'm also waiting for one.
Ambulance chasing. Ambulance chasing. A lot of lawyers believing the blogs now. Who is being defamed? So that they can go and get the money.
Yes.
All right. Well, of course, thank you so much.
Thank you.
I'm enjoying the conversation as well. We've been talking about the defamation case where somebody was awarded 5 million yesterday by Justice Musaga Mugoli, and we're going to now go on with our news, and keep talking to us in case you have any questions, views, and comments. The hashtag to use on Twitter is #PowerBreakfast. Even as you use it, do not defame, and on SMS number is still 224. Now we hand you over back to Kirigo.
Thanks, Willis and Mutegi, for that. Police have recovered an assortment of crude weapons and bang from the University of Nairobi hostels following a raid ordered by Inspector General of Police Joseph Boynet. The discovery of the weapons lifts the lead on criminal activities by students at the institution that was closed last week following 2 days of student riots. And as Michael Jenga now reports, Education Cabinet Secretary Fred Matiang'i has ordered universities to collect biometric data of all students to stem crime on campus.